football team. Ron Rivera and Jack.
All right, everybody's in that was in the waiting room.
Okay. I call this meeting to order. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which we stand, one nation, under God, indivisible, with liberty and justice for all. Welcome, everybody. Thank you for joining us on this stormy night. And with that, we will jump right into our workshop topic. And Eileen Eakins, feel free to take it away.
Okay, well, thanks for having me. And hello, board members and to the members of the public who are here. I understand this was an advertised public meeting, so that means that our board can speak freely about district business. And we'll learn a little bit more about that.
I can't hear anything.
You can't hear anything?
We can hear you, John.
Can you hear me?
John, are you able to hear us? Skylar, can you send John a message maybe?
Oh, hello, I just got it.
Okay.
All right. Can everybody hear me?
Yes.
Good.
I can.
Okay. Can everybody hear everybody? If you can't hear me, don't say anything. Okay. Good evening, everybody. We're gathered today for what will be approximately, I think, 2 hours of board training. I worked a little bit with Catherine and with Skylar to develop some topics that I think are kind of priority for now. I think we'll give particularly the new board members some orientation into some of the basics of the job you've signed up for. I'm a huge fan of training when you can get it, particularly if you're not familiar with the world of local government, just because there is a bit of a learning curve. There's a lot to know. But the more you know, not only are you better able to do your job, but you're also better able to handle kind of the slings and arrows that may come your way from people who think you don't know what you're talking about. So this will often be, will ensure that everybody is as empowered as you can be as you do your work. There essentially are going to be four total topics that we're going to cover before we're done today. I'm going to do a few kind of intros. That's the powers and protection slide that you see on your screen. And if you can't see your screen, let Skylar know, because I think we should be up and running in terms of the slide presentation. We also are going to talk about some basics of public meetings. We'll talk about public contracting, and we'll talk about ethics for public officials in Oregon. I have kind of once I kind of get on a roll, my preference would be that we kind of get through a topic and then I'll open it up for questions. So if you have questions as we go, maybe jot them down. In the interest of time management, we'll kind of try to set it up that way. I welcome your questions as we go. You get the most out of it if you feel like you understand the process as we plug along. If you feel like I'm getting way ahead of you and you're lost and want me to go back, I'm more than happy to stop and do that. So I'm going to go ahead and get started with the slides that you have on your screen. And I will be happy to provide these after the fact if you want a written copy for yourselves. So we're gonna get started with just kind of an orientation in terms of what your district is as an entity, and then also what you as a board, both your authorities and your responsibilities as members of the board of directors. So we'll start with the authority of the district. And then we'll talk about the authority of the board. And then I just want to touch very quickly on sovereign immunity and the protections that are available under that doctrine. None of this, by the way, is super complicated. If any of the terminology, don't worry about it. If it's not clear by the end, I'll be happy to answer it, you know, at a later date or when we're done with the class. When we talk about the authority of the district, now a special district, which is what your park and recreation district is a form of local government in Oregon. So you have your counties, cities, and special districts are all forms of local government. Metro in the Portland area is a form of local government. And so you are a municipal corporation. So you operate like a corporation, and many of the requirements of a corporation apply, but there's a whole layer of stuff that applies to you because you are a public entity and run by elected officials and supported by public dollars. So when we talk about local government, it includes all special districts, and under common law, which is the kind of the law we brought with us from England, there's something that's referred to as Dillon's rule, which says that a local government, such as yourselves, can exercise powers that are expressly granted by law. So those are the laws that are written down. And then those that are necessarily implied, meaning that you have to be able to do the necessarily implied things in order to do the written down things. So we always start from a position of what is the district authorized to do. So in Oregon, when we talk about expressly provided authority, there are a few things that we would look at. For the most part, special districts are referred to as creatures of statute, meaning that there are, in almost everything that you do, there is a statute that applies. And I'll walk through some of them here in this list. Chapter 198 ORS, when you see that written down, if you don't know, refers to Oregon Revised Statutes. So those are the laws of Oregon. So if you look at ORS chapter 198, that has to do with special districts generally. So there are about 1,000 special districts in Oregon of all different kinds: fire districts, water districts, sanitary districts, park and recreation districts, irrigation districts. And you are sometimes referred to as special service districts because you provide a special service. In your case, it's park and recreation services. So ORS 198 deals with special districts generally. So if you guys were going to adopt an ordinance, there is a process in that statute that talks about how to adopt an ordinance. It talks about how to form a district, how to dissolve a district, how to merge and consolidate, etc. So that's kind of this umbrella statute that most of the time you don't have to be too worried about. The more important one is that second bullet, which is called the principal act of your district, which works a lot like a city charter does for a city, and that there is a chapter in the Oregon Revised Statutes that is specific to park and recreation districts. So I put the citation up there for you. For park and rec district, it's 266, ORS chapter 266, and these are all available online, by the way, if you want to go look it up. It's kind of interesting reading, but it'll tell you what your qualifications to be on the board are, talks about what powers and authorities the district has, what the board is authorized to do, etc. So it's always a good place to start to get oriented in terms of what a park and recreation district is allowed to do in Oregon. And if you are not authorized to do it in that statute, it's highly likely you cannot do it legally. If you do, then you're acting ultra virus, which is outside the scope of your authority, and there's potential liability there. For example, a park and recreation district can't provide sanitary sewer services, thank goodness, and a sanitary district can't provide fire protection. So in other words, you have a scope of duties that you are allowed to do under the law, and you have to stick to those within that scope of authority. So everything else that you do, there is likely a statute that applies. I've listed some of the examples there: elections, bonds, contracts. There also are some administrative rules that may apply. There aren't a lot that deal with park and recreation districts, but an administrative rule, which you might see abbreviated OAR, which is Oregon Administrative Rules, are rules that are adopted by state agencies. And for the most part, they apply to state agencies, but some state agencies have the authority to regulate local governments like yourselves. So a sanitary district has to follow DEQ's administrative rules, and a water district has to follow the water resources department's administrative rules, and so on. So when you see written down expressly provided authority, it's coming either from a statute or an administrative rule or a local law, which is what an ordinance is. If your board of directors has the authority to adopt ordinances, it will show up in ORS Chapter 266, and you'll see it in the form of rules and regulations. Those are local laws that your district is authorized to adopt and enforce. So it comes in the form of an ordinance, and it has the force of law, but you can only adopt an ordinance if your enabling legislation here, your principal act, says that you can. Okay, and then necessarily implied authority is kind of stuff that it might not be written down anywhere, but it's kind of a no-brainer that you're going to be able to do that stuff, like purchasing things, employing staff, contracts, etc. So again, sort of loosely defined, but it has to pass the straight face test to be necessarily implied. So if your authority is written down or necessarily implied, go for it. You can do those things. If you're not getting your authority from one of those places, you need to be very, very careful because you might be stepping outside of your scope of authority. Okay, so within that realm, if you think of the district as a municipal corporation, the board of directors is responsible for running the corporation. And you are all elected officials and you have certain duties that you are required to do. So here's a list of the primary ones. You are responsible for ensuring that the district operates legally and in a fiscally responsible way. You are responsible for entering into any binding legal obligations of the district. Now, this is going to be important and something that comes up a little bit later. Only the board of directors has the authority to bind the district, the entity, legally. So if you're going to enter into a contract, the board of directors must vote on it and approve it unless they have delegated some of that authority elsewhere. Okay, we're going to talk about that a little bit more, but be aware that only the board of directors can bind the district legally. All right. You oversee financial operations, including the adoption administration of the budget. You establish legislation by ordinance. You can establish district-wide policies like employee policies, your public records policies, your public contracting rules. All of those things are forms of policies that the board must adopt. Where appropriate, the board can delegate authority. And that's where you have given, for example, you might give Skylar a certain amount of authority to enter into contracts. But whatever authority the staff has to be delegated formally by the board. The staff themselves can't go out and bind the district legally to anything unless the board has said they can in some sort of formal delegation. And then assuming there is a chief executive officer, not every district is big enough to have one. You guys have one, which is Skylar. The board is responsible for supervising that person. And then usually that person supervises everybody else. So those are the typical responsibilities of the board of directors. All right, here's an opportunity for you to do a little multiple choice. Individual board members have the power to engage in the following without the consent of the rest of the board. Choose all that apply. So you individual board members, what of these powers do you have? You can attend board meetings by telephone. You can establish policies. You can review personnel records. You can direct staff, or you can sign contracts. Any takers?
So
Okay,
the
I'll
question,
use yourself again.
the question is, it's hard from on my phone because your picture is right over the question.
Oh, my picture is?
Yeah.
Oh, I'm sorry. I
No,
think
that's
that might
okay.
be something you'll have to manage on your end. But I can read the options to you again. Can you attend
Okay.
board meetings by telephone as an individual board member?
Yes.
Can you establish a policy?
No.
Can you review personnel records?
No,
Can you direct staff?
no,
Can you sign a contract?
No.
Okay, is there anybody who has a different answer from those I can hear? Apparently not. Very good. You guys did very well on those. Yes, essentially what an individual board member is authorized to do is attend meetings and participate in the decision-making process. But as an individual board member, you have no authority at all, except whatever the board directs you to do, the board acting collectively. So you can attend board meetings, and yes, you can attend them by telephone. But you don't have any individual authority at all to establish policies or sign contracts, which you've already talked about. Now, C and D are important, and those are common stumbling blocks I find for elected officials, in the assumption being that I'm going to get on this board and I'm going to get to the bottom of some things. And that means that I'm going to go dig up dirt on people and find out what that director has been, or what that CEO has been up to, and basically get him fired. I have seen that happen. It wouldn't happen with this board, I'm sure. But as an individual board member, you don't really have that kind of authority. What that is micromanagement, and it can create at minimum severe morale problems, but at worst it can create certain legal problems. Now, that doesn't mean that the board isn't responsible for making sure that personnel are being managed properly, but you need to go through the proper channels, meaning that the board has to decide together what you want to do and authorize somebody to take whatever steps are necessary to resolve the issues that you have. Now, we'll talk a little bit more about that when we get into public meetings and what you're allowed to talk about in executive sessions. Sue, did you have a question?
I simply wanted to ask you to clarify, because it came up that Mike is the only elected board member. The rest of us have been appointed. And I was asked to attend an LOC meeting. I asked the same question, and the speaker said, we signed we pledged, we signed a contract. So I just wanted you to at least address, because I don't know who is listening besides we four, and I know John is on. Hi, John. But I'm curious if you can just address that, since we have not, four of us are not elected.
Good question. And technically, because there is a process if there's a vacancy on the board, and that was, we talked about ORS Chapter 198, which deals with special districts. It talks about how boards fill vacancies. Once the board member is properly authorized to fill the vacancy, they have all the responsibilities and duties of an elected official. So if you are properly appointed, I'm including you in the realm of elected officials. So you are serving on the board, you have all the same duties and obligations and all the same liabilities, frankly. I mean, it's not just all about power, it's also about responsibility. So for our purposes, you can assume that if you were appointed to fill a vacancy, you are treated the same as any person who was elected directly to that office. Does that help? Okay.
I hope it helps me.
Good. Well, that's that's good. That's what we want. All right. Now, when the board takes action, meaning you decided to do something, it must be done at a properly called public meeting. We're going to talk about that shortly. Requires a quorum to be present. Okay. For you guys, what's a quorum? Three. Majority, 3 out of 5. Generally requires approval by a majority of the board. In most cases, you need everything, whatever your decisions you make, need at least 3 members to approve in order for it to pass. Now, that doesn't mean a majority of the quorum. So let's say that you have a 5-member board and 3 of you show up for the meeting, you have a quorum, but if only 2 of you vote to approve something, does it pass?
No.
No. That's the right answer. You need a majority of the board, 3 out of 5, to approve something, even if some are not there. That's why vacancies can create some difficulties in getting anything done. So, and all votes have to be taken publicly. We'll talk about that when we get to open meetings, public meetings. You can't vote secretly. Sometimes I'll get that question directly. And no, you cannot vote in secret. Okay, I want to touch on this real quickly, just because it can be reassuring if you aren't already familiar with the process. Sovereign immunity is a legal construct. Many of you may be familiar with it already. It's something we kind of brought over with us from England when we settled here in the colonies. And essentially what it means is that a government body, meaning the king, can't be sued by the common folk, except to the extent the king says you can. So in other words, the sovereign is immune from lawsuits unless there is a specific law that says otherwise. So for our purposes, we're going to look at state law that says, how can one go about suing but either the district as a governmental body or the board of directors? Okay, so Oregon has something to say about that. And here's how, if you can see that, legal actions against public bodies, there is a statute for each type of lawsuit that might be brought. And one has to, if they're being sued in contract, like breach of contract, you're treated like any other private party would be. There's no special process associated. The district can be sued for breach of contract, and you can sue for breach of contract. Quiet title, which are disputes about ownership of real estate. Again, the district is treated like any other private party would be. The big one, which many of you probably are familiar with, is the Tort Claims Act. So tort, if you don't already know, a tort is, it's not a criminal law. It's basically, it's a violation that you had a duty to somebody and you breached that duty. And because you breached that duty, they incurred some kind of harm. Either their person was harmed or their property was harmed or something was harmed, some interest of theirs was harmed. And what a tort action usually is looking for is money. They're money damages to pay me for the damage that you caused to me because you breached this duty. So claims for negligence, claims that you did your job badly, that's a tort claim. So Oregon has a lot to say about tort claims just because they can be extremely expensive, as you can imagine. So in order to make sure that public entities aren't being, have all of the public dollars sued out of them, the Oregon Tort Claims Act establishes a couple of limitations. This is some text from the actual statute itself. The underlined sections are the ones you should be concerned about, because in the gist of it is that if somebody is harmed by something the district does, your grounds guy runs over somebody's dog, God forbid, or your staff gets in a car accident en route somewhere and somebody gets hurt, or the board does something bad and whatever decision you've made results in somebody being harmed, and then the district gets sued in tort, meaning a civil lawsuit, and somebody is claiming a bunch of money that they want to pay them a bunch of money. Under the Oregon Tort Claims Act, if somebody brings an action against the board of directors or against a public employee or against the district as an entity and the individual people associated with it, if that person was acting within the course and scope of their duties, meaning they were just doing their job and something bad happened, then under the Oregon Tort Claims Act, the district itself steps into the shoes of the individuals and provides indemnity, and the lawsuit proceeds against the district so that you individuals are not liable for that harm. Okay. So what you should take away from this is a lot of times when you are doing your work, there's this fear, oh my God, we're going to get sued, we're going to get sued, we're going to get sued, I'm going to lose my house. And what you should realize is that the law has thought about that, and there are protections there as long as you are doing your job to the best of your ability. Even if you screw up, do the best you can, and essentially any lawsuits would then be, you would be dismissed as an individual. The lawsuit proceeds against the district as an entity, and then the district's insurance kicks in to cover whatever the defense is that's required. So there are protections available under the Oregon Tort Claims Act, and that the Oregon Tort Claims Act imposes damage limits on how much can be recovered depending on the type of incident. Is somebody asking a question?
Yeah, I'm sorry. Skylar, Celeste has been trying to get in the meeting. She's in the waiting room.
I made it in. Thanks, Erica.
Oh, sorry.
Hi, Celeste. Okay, we just got done talking about lawsuits. So again, we won't spend a lot of time we won't do a deep dive on any of this in the time we have available, but I just kind of want you to be aware that there are protections available to you, and your responsibility is to do the job to the best of your ability so that your district can help rescue you if something goes wrong. Okay. All right. I'm going to go move into public meetings shortly, but I want to give you a chance if you have any questions about what I've talked about so far.
Well, I have a question, and I
Okay.
don't know where it fits.
All right, well, throw it out there and I'll tell you.
So, yes, I know you will have the answer. Thank you. So I'm trying to wrestle with multiple opinions of what is a private citizen versus a public citizen when you are elected or appointed to a position. And I've heard that when you state I'm acting as a private citizen, even though you have a public role, that you are free of that responsibility, but I've also been told that's not correct. And I was wondering what the rules are.
Well, maybe we'll help. Can you give me an example of a situation in which you want to be clear about which applies?
If I am on this board and I do something where I decide to go be vocal about a political situation, and if I say, well, I'm acting as a private citizen, then my public role, is there any what is it, reason for me not to be able to speak out because I have that public role, versus you have that responsibility as a public position as a part of a board. So you want to be careful and respectful of what you say and how you act, because you are part of a board, Is that helpful?
Well, somewhat, yeah. I think I know that the nature of that concern. And if primarily, I'm guessing it's going to come up in the context of you're expressing an opinion, and you want to clear that this is your opinion as Sue and not your opinion as a member of the board of directors, correct? So again, it's going to be very context specific. But as a member of the board, you're entitled to your opinions. There's nothing to prevent you from expressing them. So it depends on the context. If you have been authorized by the board of directors, for example, they say, Sue, we need you to go to the City of Seaside meeting and represent our position on the bond that they're trying to pass, or something like that. In that context, because you've been authorized by the board to speak on behalf of the board, you are clearly speaking on behalf of the board. If the board has not sent you, then you are, in most situations, just acting on your own. All right, you can't speak for the board, you can't speak for the district unless they have said you can. All right, so you should not ever say that you are unless you know for sure that you are. You can certainly say, I'm on the board of the Park and Recreation District. I would like to be able to go talk about this with them and get back to you, or something like that. Okay, so you can't represent yourself as speaking for the board unless the board says you have. That you can. So in most contexts, if you just want to express your opinion as Sue Coddington, citizen, in most contexts, it's not going to be necessary for you to explain that. You are either representing the board of directors for the Park and Recreation District, or you are not. So let's take the same example, the City of Seaside. Let's say the Park and Rec District has no opinion whatsoever on the bond measure. And you show up and you say, I'm going to speak as Sue Coddington, resident of wherever you live, and this is my opinion as a citizen, then that would be the appropriate response. So I can't say that I can give you like a hard and fast line that you should observe, but if you have any doubts, if you are concerned that you are going to be perceived as speaking on behalf of the Park and Recreation District, you should always make it clear that you're not. Unless you are. So depending on the situation, it really depends. Let's say you want to write a letter to the editor and you're speaking about, dog control at the local, I don't know, I'm having trouble coming up with examples. So that's kind of a long rambling answer to say it really depends. You should know who you are and who you're representing. And if others are in doubt about who you are representing, then you need to be clear about that. Now, where it could get a little tricky is, let's say that the board of directors for the Park and Recreation District has taken an official position on something and you happen to disagree with them. You didn't vote for that, but 3 out of 5 did, so that's the official position, right? So it is perfectly okay to still have an opinion. You can say, well, I as a public citizen feel this way. However, I am not speaking on behalf of the board, which feels differently. So you may need to just sort of clarify, depending on the situation, who are you representing, which hat are you wearing right now? So there isn't like a rule written down anywhere, but it's going to depend on the context. If the people you are talking to are likely to assume that you're speaking on behalf of the Park and Recreation District, then it's on you to make it clear that you're not. Does that help?
Yes, thank you.
I feel like that was a lot of words to just basically say it depends.
Well, I have a specific idea in mind, but I am uncomfortable speaking it.
Well, I kind of got the feeling there was a situation in particular that you're trying to address, and maybe maybe you can take it up individually with Skylar, and I can work with you and him on specifics if you need more specific information. Okay.
Thank you.
Okay. Any other questions before we talk about public meetings? Okay. We covered a lot of this already the last time I met with you guys. We did it in a more informal way, and I'm just going to present it a little bit more in a little more organized fashion. And then again, when we get to the end, you may have some specific questions that you want to ask. This is kind of the most important job that the board has because it's all about meetings and there's a lot of requirements for meetings. So this is good, important information to have. And for those of you who've been doing this for a while, this is probably going to be a lot of review, but refreshers are always helpful, especially when the darn laws change. Okay, so we're going to review the law. We're going to talk about notice and we're going to talk about executive sessions. This is the Oregon statutory policy on public meetings. I'm going to move my screen there. And essentially that says the Oregon form of government requires an informed public aware of the deliberations and decisions of governing bodies and the information upon which such decisions were made. It is the intent of the public meetings law that decisions of governing bodies be arrived at openly. So notice the date on this, the 1970s. There was a big push for transparency in government, and this law has stayed pretty much the same ever since. And essentially what it means is that you should always default to transparency. There are going to be specific times when you should not and where you may not, but for the most part, assume that all of the district's business needs to be done in public or it has to be accessible to the public. Here are the requirements of the public meetings law. To open meetings of governing bodies to the public, to give notice of the time and place of the meetings, and to make them accessible to those who wish to attend. Now notice that there is no requirement that the public gets to talk at your meeting. This is, you should always consider your board meetings as business meetings of the corporation, okay? Meaning the board of directors is getting together to run the district and make decisions that relate to the district, and you just have to do it within public earshot, okay? There is a common misperception in the public that I am allowed to say whatever I need to say at your public meeting and you're supposed to let me. Now, don't walk away saying that the lawyer just told us we are not allowed to let you talk, because that isn't right. Essentially, what this comes down to is it's up to the board of directors to decide how much public input do you want, how do you want it, when do you want it, and you can put some parameters on public input in your meetings. You never want to allow the public to derail the business meeting of the board. That's why you're there. You're elected to be on the board, to make decisions for the board, and the public gets to listen in most of the time. So they're allowed to attend, and if you let them speak, you can decide what the rules are. And I've worked with Skylar a little bit already on how to develop some procedures to make sure that you can manage public comment. I think public comment is always a good idea. It's always good to hear from your constituents, but it's also important to recognize what authority the board has to manage it so that you are not in a position of having to constantly, be having to defend yourself from those who would like to disrupt and derail your meetings. Now, the distinction there is if you are having a public hearing, you have to hear people. Now, a public meeting and a public hearing are not the same thing. A public meeting is a meeting. A public hearing is whenever the board says you're having a public hearing, or if there's a statute that says you have to have one. There are certain situations where public hearings are required. The budget is an obvious one. Every type of special district has to deal with budget hearings. If you were to adopt rules and regulations by ordinance, there's a requirement that you have a hearing so that you can hear people on it. But even then, you are allowed to decide the parameters of that. The topic that you will hear people from, how much time everybody gets to speak, you know, whether they can speak once or multiple times, whether they can share their time with each other, all that kind of stuff is up to the board to decide, but you don't have to hear from people unless you are having a public hearing. It is perfectly okay for the board to say, in the interest of time, we are not having a hearing from the public today. That's perfectly okay to do that. The only time it's not okay is when you were going to have a public hearing and then you aren't hearing from anyone. Does that make sense? So this is kind of an important thing for many board members to recognize, because I want you to come at it from a position of transparency, but also awareness and power. Okay, this is your board meeting. You get to decide how it goes, and that includes managing the public in what is a fair and reasonable way. And you always want to treat everybody the same. Don't play favorites in terms of who gets to speak and who doesn't, but set rules and require everybody to follow the rules, and that ensures that you have a respectful and productive meeting, okay? Now, any meeting where a quorum of the decision-making body is present and it's discussing or deliberating toward a matter of business is a public meeting. Now, for you guys, we already established a quorum is 3. So anytime any 3 of you are together and discussing or deliberating toward a matter of district business is a public meeting. So both of those things have to happen. A quorum has to be present and you're talking about district business, okay? If neither of those things is present or only one, it's not a public meeting and you don't have to be concerned about complying with public meetings law. Now, one distinction that's important, and it tends to come up not all that often, but if you have created, let's say, an advisory body or a committee, and their task, the board has tasked them with coming back to the board with some kind of recommendations or advice, that is considered a public body for purposes of public meetings law, and these requirements that I'm going to talk about apply to that group as well, even if you don't have a quorum of the board on that committee. Okay, make sense? Okay, so, and notice is required for all public meetings. All right, so which of the following is allowed at a public meeting? Choose all that apply. A, shouting at each other. B, meeting outside the district. C, meeting on the second floor of a building with no elevator. D, holding the meeting when no notice was given. Or E, smoking.
Eileen, I have to laugh at some of your multiple choice options.
Believe me, almost all of these are taken from real life.
I think you can actually legally shout at each other.
Guys, you can
although it's
shout.
unpleasant.
Okay, hold on, reading. I think we can meet outside the district as long as we give notice.
Anybody else have commentary?
I don't think any of them were allowed.
It seems to me that shouting would be allowed too, unless the board decided that it was against the rules, right? Like unless we designated it.
We have rules of decorum, don't we?
Right, exactly. So, but I think those are self-imposed.
But they're
I'm
not.
not sure about the smoking one, but I just don't know smoking laws in Oregon. It would seem like smoking is not allowed in public places. So I would say that was off the table too. But the other ones I don't think you can do.
Okay, good discussion. I'll just walk through them with you. And those of you who said shouting at each other is allowed at a public meeting. Yes, it is. Doesn't mean it's a good idea. Doesn't mean it doesn't make you look ridiculous. And I have been to meetings, and some of you may have as well, where people shout at each other, and
that was a previous board, Eileen.
Well, and I wasn't necessarily referring to this board. I have a bunch of special district clients and city clients, and shouting at each other is a sign that something is horribly wrong, but it happens. So shouting at each other is allowed, but I don't recommend it. Meeting outside the district. Now, under the public meetings law, you are required to meet, and somebody addressed this, but the general rule is you're required to meet within the geographic boundaries of your district if it's feasible. So for your regular meetings, the default should be meeting inside your district. You can't have your meeting in Maui as much as you might want to. But you can, you have a meeting space and it should be located within the geographic boundaries of your district. There are a couple of exceptions there. Somebody referred to one of them, which is occasionally you might have some business related reason to meet elsewhere, like you're having a joint meeting with some other entity, or you are having a site visit somewhere that's outside your boundaries or something like that. You can meet outside the district periodically, but again, your meeting notice needs to be clear that that's what you're doing so that anyone who wants to come can come and listen in, because it's still probably going to be a public meeting.
Eileen,
Yes.
that just for me kind of isn't reflective of kind of where we're at with COVID and Zoom. I mean, I'm assuming that technically if we had a Zoom call, people could be really wherever they needed to be. I don't know.
Well, and you raise a good question. I'll touch periodically on the COVID restrictions. That's a very good point. And some of you may be familiar with the fact that Governor Brown, early in the pandemic, ended up issuing an executive order specific to government entities, because people were kind of approaching their budget hearing time, and the budget hearing requirements are that people must be allowed to be present and yada yada yada. So there is currently in effect an executive order that modifies some of these requirements and makes it possible. My guess is also that we'll see what happens, but when the COVID restrictions are lifted, what does I want to say? For now, the public meetings law has a default that you're going to meet within your jurisdictional boundaries. And again, this promotes the idea of transparency and your constituency being able to sit in and listen and yada yada. The laws generally, in my experience, are somewhere between 5 and 10 years behind technology. My guess is that once we come out of the COVID situation, some of this virtual meeting is going to become more normal and more normalized. And the law may change to allow for some kind of virtual meeting and impose some other kinds of restrictions on it. For now, the COVID virtual meetings are allowed under the current executive order. Now, interestingly about this requirement now is that it is also perfectly okay to call into a meeting for board members, or do a speaker phone kind of thing, or a Zoom meeting or whatever. That was always legal. You always could, not always, but within the last, I'd say 10 years or so, that is still permissible, but this law has not yet changed. Other than to say that attending virtually is allowed. So we'll see. But for now, you should try to meet within the jurisdictional boundaries of your district. And just in case you're worried that you're breaking the law right now, you're not. It's perfectly okay to do what we're doing here. Holding the meeting when no notice was given. You're going to have to give notice for every public meeting in order to make it legal. We're going to talk a little bit about that shortly. And then smoking under the public meetings law, there has been for quite some time a prohibition on smoking in a public meeting room. I checked recently and it's still there, and it still has the same original fine that it had when it was adopted in the 70s. And it says the technical language is no smoking instrument. So you can't smoke anything from anything in any way. And the penalty for doing so is, under this law, is $10. This has been supplanted by the statewide prohibition on smoking in and around public buildings, but it's still on the books for this law. Just so you know, if you want to ever get into a weird trivia contest, you can say that you know that to be true. Okay, for a 7-member board, this is important, which is not a public meeting. 3 members call a 4th one on the phone to discuss firing the manager. 4 members go fishing together. C, the chair sends a group email to the rest of the board to ask how to vote at the next board meeting. D, 5 members attend a work session at the home of the chair to hammer out some personnel policies.
B.
B, I hear B. Anybody have a different answer?
Yeah, I'd say B also, with the exception that if the 4 members go fishing together and discuss board business, now it's just wandered into a public meeting territory.
Any other answers? Okay, good. You guys had, some of you have had good training in the past, hopefully for me, but I'd be happy if it's from somebody else as well.
Eileen,
Yes.
just question on that. You know, just being from the nonprofit sector, you know, often boards do quite a bit of kind of team building or like activities together to kind of build that, you know, trust in a way. So I'm curious, you know, for example, 4 members go fishing together. I mean, are those kind of activities where you're spending time together, or, you know, just at least getting to know each other better, that's seems allowable from what you're saying?
Yeah, well, yeah, and generally it is. Let me just walk through each of these, and we'll just, they're each there for specific nuances that they can offer. The first one, we remember we have a 7-member board. So for 7-member board, what's a quorum?
4.
Good. So you have 3 members, and they call a 4th one on the phone. That's a public meeting because you have a quorum. Even though one of them is on the phone, it still makes for 4 people, and they're still discussing or deliberating toward a matter of district business. So the criteria for a public meeting are met. In comparison, when you look at B, 4 members go fishing together, and the earlier comment that, well, 4 members going fishing together is fine, and it is. That's not a public meeting. And I'd like to say that if you like each other well enough to hang out together outside of a meeting, that bodes well for your district. However, the point was made, and it is an excellent one, that you just have to be very mindful of what you talk about. Because you have 4 people there, that is a quorum. It's not a public meeting unless and until you start discussing district business, and that can be something you drift into without really meaning to, because you have it in common. So, you know, the old, you know, in the car on the way to the old fishing hole, this stuff might come up. And so it's incumbent upon everybody to recognize when a public meeting has been created and when to stop discussing district business in that context. The appropriate thing to do is to say, well, let's take this up at the next meeting, and now we can talk about bait or whatever is not district related. So I hope that answers your question. Yes, team building in that context is fine, as long as it's like fun activities to get to know each other better. However, you need to be very careful that you are not engaging in or discussing district business. For example, you know, we're all going to go do the ropes course and then follow that up with an orientation on how to be a board member. You then kind of morphed into public meetings land once you started the business part of that activity. The third one is there to say, just to remind you that email communication can create a meeting, even if it's not in real time. You have to be very careful about group emails or reply all emails or multiple forwards of emails, because not only do you have the potential to create an improper and illegal public meeting, but you've also created a handy paper trail. So anybody who wants to can show that you did that. So, just be careful of emails and be aware of the fact that the same requirements apply to email that would apply if you were there in person, even if it's not all happening in real time. It's okay to communicate with the general manager. It's okay to communicate one-on-one, but as soon as you get to the point where you are involving 3 people, 3 board members in that conversation, you are potentially having an improper or illegal public meeting. So be very careful of email.
Eileen, if something is raised via email to the whole board, you know, let me find an example. Let's say Skylar emails the whole board something that, you know, he wants to look at. I mean, is it appropriate just so that everyone is aware for one person to reply and say, this is something, this is great. Let's discuss at our next meeting, or let's get together and set up a meeting to discuss. I mean, at that point, it's really not inappropriate. It's just stating that we need to discuss it, right?
Yeah, at that point, I think you would be okay if all
Yeah.
you're saying is, like that idea, let's put it on the agenda. I
Right.
don't think that's a problem.
Okay.
So that kind of, at that point, you're not really discussing or deliberating, you're just responding to something Skylar said, and that's all
Okay.
fine.
Okay. It's more with the decision part or
that's
right.
a big part of it.
Yeah.
And again, you're sort of treading a very careful line there, because if Michael responds and says, love that idea, let's put it on the agenda, and Celeste responds, well, I don't really like that idea, Michael, here's why. And then Erica says, but what about, and at that point you are then in a conversation. Okay, so it's, again, just be aware of that there are limits and know what they are and err on the side of caution. And it's always perfectly fine to say, let's take this to the meeting and talk about it then. That is the appropriate response when you find yourself being drawn into a conversation outside of a meeting that involves more than just one person. Okay.
This to me is a question, like what to deliberate, what goes on the agenda is this would be a question that I've had a little bit that I haven't had clarity around. In my experience, in the nonprofit boards that I've participated in, usually it's the chair's role to develop the agenda. In our case, I think most of the agenda writing is coming from our staff, from our executive director. And so I'm just curious, how does that work? And I've elevated things that I'd like to see on the agenda, and I just forward it both to the staff and our chair. But how is that usually managed, deciding what will be an agenda item for a public?
It really can vary depending on how you run your district. The most common example I see is if there is a manager, the manager is responsible for developing the agenda, usually in consultation with the board chair.
Okay.
Usually it's the two of them, but it doesn't have to be. It's perfectly okay for other board members to send either of those people ideas for the agenda and incorporate that. That's all fine too. Where I would recommend you be careful is if you find yourselves in kind of a group chat about what needs to go on the agenda next week. It should not be a group decision. You can certainly have input, but ultimately the best way to approach that is let the manager handle that in conference with usually the board chair or whoever it is you want to be responsible for that. And then the rest of the board can send your ideas to one or both of those people and let them take it from there. That's the cleanest way.
Okay.
Okay, and then the last one is there just because this is one of my own personal pet peeves is I occasionally, I have one client in particular who is always doing this, and she would talk about how they had a work session and did this, that, and the other. And I said, well, can you send me the meeting notice for the work session? And she said, oh, well, it wasn't a meeting, it was just a work session. And again, we get back to remember the criteria are a quorum is present and you're discussing or deliberating toward a matter of district business. So in this case, was a quorum present? Yes. Were they discussing or deliberating toward a matter of district business? Personnel policies, yes. So it is a public meeting because it has the requirements of a public meeting. The fact that you don't call it a duck doesn't mean it's not a duck, okay? So be careful of, substitutes, it's really just a work session. It's in fact, it is a public meeting if both of the criteria are met, no matter what you want to call it. Now, there is an exception in the public meetings law for trainings like this. This training could have been done and have it not be a public meeting and none of those requirements applied. When I talked to Skylar about scheduling it, my recommendation was go ahead and send out the meeting notice because then that frees the board up to discuss whatever you want to. If the meeting notice had not been sent, then this technically didn't have to comply with public meeting requirements, but the discussion or deliberation component of that would have been pretty limited. You could attend, you could listen, but you probably couldn't discuss much, okay? So, if you wanted to just do a training and just have somebody talking at you without any conversation, that is not subject to public meetings requirements, and it's an exemption in the law. Okay, what's the difference between a legal public meeting and an illegal public meeting?
Notice.
Brilliant. That's the right answer. I didn't even give you the answer in writing because I wanted to see if you knew it. So yes, whoops, sorry. Getting ahead of myself. So if you have a quorum present and you are discussing or deliberating toward a matter of district business, the way to make that legal is to send out notice as required, public notice, all right? Which means the public will be able to be there if they choose to, but you get to decide, what they can do once they get there. I see this sometimes in the context of, we want to have a Christmas party at Erica's house, and then we want to follow up with a board meeting. We don't have to send out meeting notices to that, do we? And it's like, well, yeah, you do. If you want to actually have the meeting, you have to invite everybody to come to Erica's Christmas party. But if you want to do it legally, that's how you would do it. All right. If no notice was sent, then you are in illegal public meeting land, probably. All right, how much notice is required? Here's the standard in the law. General notice to the public at large, actual notice to specifically interested persons. We talked about this, I remember, when I met with you guys last. General notice to the public at large is just whatever is the appropriate amount of notice that a reasonable member of the public could come. Again, a few days to a week is usually the norm. That seems reasonable. If you're only going to have an executive session, it's the same as for any other regular meeting. A special meeting, which is anything outside of your regular meeting schedule, you have to give at least 24 hours notice to the public and the media. And then an emergency meeting is something you just give as much notice as possible under the circumstances. If an emergency, depending on the emergency, if we find out Skylar's been embezzling, and you found that out, at 3 o'clock in the afternoon, and you need to have a meeting at 4, that's an emergency. Okay, your lack of planning is not an emergency. So you just give as much notice as possible under the circumstances. At minimum, notify the media. All right, which means a phone call, an email. If anybody uses faxes anymore, send a fax. Yeah, okay, so that's general notice to the public at large, actual notice to specifically interested persons. Putting it on a website is perfectly fine. If somebody wants to be notified, you can certainly direct them to the website where they can help themselves. If for whatever reason they can't access the website and they ask to be specifically notified, you should have a process for making sure that they are notified. And then again, you always want to make sure the media is notified. It doesn't mean you have to publish in the newspaper. You can if you want to, but you don't have to. Just make sure that the public is notified and that the media are notified. Okay, true or false? If no members of the public attend a district's board meetings for 1 year, the public body is not required to send out notice for meetings.
False.
You think some of these are kind of stupid, don't you? But it actually does happen. I have had clients who say, well, nobody ever comes to our meetings, so why would we send out notice?
Because somebody might change their mind.
They might, first of all, they might come if you sent out notice. And second, even if they didn't, they could also claim that you are violating meetings laws by not sending out notice because you're required to do it regardless. All right. All right, what happens if you don't give proper notice? Any member of the media or anyone affected by a decision of the public body may sue. We're going to talk about media shortly because I know that question has come up fairly recently. If they are successful, if they show that you improperly did not send notice or send it improperly, then that makes your meeting illegal. And whatever decisions the board made may be voidable or void, depending on if the court finds that you kind of just you screwed up, you didn't mean to do it, but you did it wrong, then the decisions are voidable, meaning you can fix them. You can go back and ratify them. You send notice out like you should have, you vote again, and you can ratify the decision, and it cleans it up back to the original date when it should have been done correctly in the first place. If the court finds that you were deliberately violating the law or just not even bothering to notice what the law required you to do, then decisions that you made can be made void, meaning they become canceled. which might be no big deal depending on whatever the decision was. But I've never seen this happen, but the example I give when I try to think of what would be the worst case scenario I can think of for voiding a decision, it would be if a court invalidated the board's decision to approve the budget. Because operating without a properly approved budget violates all kinds of laws, including making board members personally liable for expenditures. So that is a potential worst case scenario I can think of. But one that could be also problematic would be you approved a contract, the contractor has started to perform, and then the court declares that contract to be void. There are potential liabilities for breach of contract at that point, yada, yada. So that can be problematic. Probably a bigger penalty is that if they are successful, then you have to pay their attorney fees, which may be substantial if you have ever had to pay attorney fees in a civil action. And then if it's a violation of the executive session laws, it's the board members are personally liable. This is not something that the district can indemnify you for. It comes out of your pocket and you are not insured for it. Your homeowner's insurance might help you, but not the district's insurance. And the penalties of up to $1,000 per violation and attorney's fees. It's considered an ethics violation. So the tail on an ethics violation is 4 years. So in theory, $1,000 per violation for one meeting every month plus attorney's fees for 4 years is a lot of money. So not to put the fear of God in you, but complying with public meetings laws is not that hard. So I would just recommend learning how to do it correctly so that you don't have to worry about any of these penalties. All right. True or false, meeting minutes are only required when the board votes on something or holds an executive session.
False.
False. You are correct. Meeting minutes are always required at a public meeting. They become part of the permanent archives of the district. We're going to talk about that when we get to public records, but your meeting minutes are a permanent record of whatever decisions were made at your board meeting. So they should be clear so that anybody picking them up tomorrow who was not at your meeting and anybody who wants to pick them up 25 years from now who was not at your meeting should understand what happened there. If you don't have a copy of the Oregon Attorney General's Public Records and Meetings laws handy, I don't have mine with me because I'm at my house, unfortunately, but that's an excellent resource and it includes an appendix on how to prepare minutes. I don't know that anybody needs it there, but so you know, there's lots of help out there for how to prepare good minutes. That manual, by the way, is available for free online if you want to go look it up ever. I'm guessing Skylar can find it for you if you want it.
Can you say the name of it one more time?
Sessions. I'm sorry, question?
Can you say the name of that one more time?
Sure. It's the Oregon Attorney General puts it out, and it's called the Public Records and Meetings Manual. If you go to the Oregon Attorney General's website and look under publications, you will find it there. It is now online, it's searchable, it's free. They also have a printed book you can order for, I think, $25. So the one that I would have showed you if I'd been smart enough to bring it home with me is dated, I think, from 2011, because I didn't see the point in ordering a new book because you can get it online. So lots of help there if you have questions about public meetings and public meetings and records. You are required to take minutes at executive sessions as well. Yes, you can record them. Video recording, audio recording, any kind of recording, digital recording are all perfectly fine. Or you can write minutes down. Either of those options will work. The minutes of your executive sessions are usually exempt from public records disclosure. We're going to talk about public records disclosure shortly. So make sure that you store them separately from your regular meeting minutes because they may be, you want to make sure you're not inadvertently disclosing them. But they are discoverable in a court of law. So just because you're having the conversation in executive session doesn't mean that somebody can't find out about it eventually. So be careful that you are complying with executive session laws as well. Can we tape record the meeting instead? We talked about that. Yes, you can record them in any form that you want to. If you make a final transcript in writing, like you summarize them and put out a summary in writing, which is often a good idea for the public consumption, That's fine too, but just remember that both of those then are public records and they may have different retention requirements. So be aware of that. You can't just toss the recording because you summarized it. All right. Can't we just post a running notice somewhere giving the time and date of the meetings? I see this a lot with, particularly with districts that send out like invoices, like water districts send out the water bill or the sanitary bill or whatever. And at the bottom, it'll say, you know, the board of directors meets on the first Thursday of every month at 7 p.m. yada, yada, which is awesome. That's great if you're doing that. But it is not, it doesn't completely satisfy the notice requirements because you are also required to include a proposed agenda. And again, it's a proposed agenda. You're not married to it. You're supposed to sort of give the public a general idea of what you intend to talk about so they know, and so you know. But you don't have to talk about it even if it's on the agenda, and you can add things to the agenda at the time of the meeting. That's all perfectly fine, but it should include a proposed agenda. Again, this goes to transparency and notice and making the public aware of the business that you intend to do. What should be in the minutes? I won't spend a lot of time on this because you have staff, I'm assuming, who handle all this, but basically it should include whatever was discussed, who voted, and how. Your voting record is public information. Again, we talked about how you can't vote secretly. So if there was a split vote, for example, the minutes should reflect who voted yay, who voted nay. If it's unanimous and we know who was there, then you don't need to break it down that way. But you are responsible for your public voting record. Okay. I want to get to executive sessions just because general public meetings are fairly easy to handle. You do those all the time. Executive sessions tend to create a lot of questions. And there are, in my experience doing this work, a lot of sort of either inadvertent violations of the law or people who sort of misunderstand what the law requires. So I'll cover this, and then if you have questions, feel free to ask them. So an executive session is defined in statute, or it's any meeting or part of a meeting of a governing body which is closed to certain persons for deliberation on certain matters. So you are meeting in private. The public is not allowed to come. I'm going to get into the requirements in just a second. But remember, you can't vote in executive session. If you are going to take an official vote, take action of any kind, it has to be done in an open session, either immediately after the executive session or at the next meeting. But you can't do it in executive session. Well, you could do it, but it's not legally binding on anybody. All right, who can attend an executive session? The board members, in almost every case, must be allowed to attend. There are going to be exceptions if they have conflicts of interests or things that might rarely come up. But for the most part, your executive sessions will include your board and anyone the board authorizes to be there. So the board probably is going to authorize Skylar to attend. You might have somebody there to take minutes. And then if you have a guest of some kind or an expert you want to talk to, the board can decide who gets to be there. And then members of the media almost always must be allowed to attend. Now there is again, this is an area where the law needs to become clearer. There have been some kind of attorney general opinions on this, but no legal action that I'm aware of in terms of who qualifies to be media. The obvious answer historically was, you know, you got your newspaper reporter, which is almost always for local governments, who is media. You may have radio coverage, you may have television coverage, and those were kind of the big three. But as we all know, over the last several years, everything's gone online, everything's gone digital. So there's a debate right now about who is media. If you find that you are having questions about that, what I'm recommending now for boards to do is establish a policy whereby you decide who, and it should be a fair policy, who you consider to be representatives of the media for purposes of public meetings law. As long as it is not unfairly restrictive and you have kind of, you have some representatives there who can speak, who can represent to the public, then I would say your newspaper reporter is the likely one who's going to attend. You also could name a local radio station or a local TV station, and those people are allowed to attend. But otherwise, you aren't going to consider your local blogger a member of the media. Okay, we won't get too far afield on that, but be aware that that's something that the law has to catch up still with that. Information discussed in executive session is confidential to the board and anyone else who attends. If you blather about what happened in executive session, you are essentially waiving the confidentiality for everybody. So don't blather. When the board chair convenes the executive session, it could include a caution, should include a caution that media are invited to attend, but please do not discuss, please do not report on what's being discussed in the meeting. Now, one other point I want to make about media is if you have someone, a media representative there, they have, through their own journalistic ethics, they should know that what happens in executive session stays in executive session. They are not there in that capacity as a reporter. They're there as a kind of a watchdog of government. However, that is only if it is a properly authorized executive session. If while you're in the executive session, you decide to bring up something that should not be discussed in executive session legally because it's not properly authorized, it's fair game for them to report on that. So this is where it's helpful for the board to understand what the parameters of executive session are. If you don't want it blathered in the newspaper, then be aware of what the limitations are on what you can talk about. Celeste, did you have your hand up or were you just gesturing?
Oops, I had my hand up, but I think Sue did also. I can ask a quick question. So one of them you answered, I think, that around sort of the journalistic integrity pieces and whether or not somebody, and I was just wondering, so what are the ramifications if that happens, if something is shared outside, something from executive session is shared by somebody who's represented the media? The other piece I was wondering, but again, maybe there isn't a clear answer to this, like what if somebody's an internet blogger or something like that, and does that represent the media? And do we just take that by a case-by-case basis? And is it the board responsibility to both vet and educate somebody attending as a member of the media regarding their journalistic responsibilities?
First of all, no, it's not up to the board to lecture about journalistic responsibilities, but with respect to the blogger, that's what I'm saying about adopt a policy. Yeah. I recommend being proactive about that so that you have a policy to rely on. So that if somebody says, how dare you, I'm a member of the media, you can say, well, thank you, but for our purposes, this is who we consider a member of the media. And if they want to pursue it, they can. But again, it hasn't been tested in a court of law, but right now, it would not make a lot of sense for a judge to agree that anybody who claims to be media is media. All right, it doesn't make sense. It completely subverts the executive session privilege. Okay, so I don't think any court would rule in favor of somebody claiming that they're media. However, the board has a certain amount of authority to kind of define that for yourselves, as long as it's done reasonably and as long as it doesn't unfairly discriminate against what we consider to be traditional media or prevent, basically be an improper, it brings in all kinds of constitutional ramifications. But my recommendation is for my clients is to adopt a policy and have a conversation about who you want to have included in that policy and define it. And then if somebody wants to challenge it legally, they certainly can. I don't think they would win, but it would be better for the board to be armed with a properly adopted policy than to have none and just decide it on a case-by-case basis, because then you're just kind of being arbitrary, okay? So the challenge may come eventually. Hopefully it will be against somebody else and not you, but it would be a good idea to at least have the conversation. There is also something that's called discretionary immunity, meaning that if the board deliberates properly over something and makes the best choice you can under the circumstances, there is some legal protection for that decision-making process. Basically meaning you are allowed a certain amount of discretion, reasonable rules for how you conduct your business, and as long as it's not arbitrary or capricious or blatantly illegal, most courts will uphold it. So again, that's my advice. And then the ramifications for blathering, first of all, I teach this class or variations on this class all over the state, often, and have been doing so for many years. And I always, whenever this question comes up in the context of a larger classroom, I always ask, has that ever happened? Has anybody in this room ever had a reporter, and again, let's take, I don't know, the Daily Astorian is probably your local paper, right? Or is there another one? Seaside Signal.
Yep.
If that reporter comes to your executive session, have you had the experience of having them take that information and blather it on the front page?
Not them.
Well, exactly. That's my point. Is those who are legitimate media, and I know that is a loosely defined term, but the ones who are professionals and who are approaching this professionally, they know what their professional ethics are and will follow them. I have found it's extremely rare. I have rarely had a client, again, in all the years I've done this, they worry about it. They think it's going to happen, and what happens if it does happen. But I find that generally the legitimate press, it's not going to be a problem. Where you may run into an issue is if you have a rogue employee or reporter who decides that they're going to try it and see what happens. And in that case, I don't know that there isn't a lot of legal weight to put behind it, but you could certainly bring it to the attention of the publisher, bring it to the attention of the editor, make a lot of noise about it, because that's not what's supposed to happen. And if they want to continue to have access to your meetings, you should be able to trust them to not do that. So I would make a big stink, not necessarily a lawsuit, but certainly in the court of public opinion, they should be held accountable for that. I hope that helps. Yeah, Sue.
Well, I appreciate what Celeste has asked, and I don't know how to phrase this in a public meeting about my questions, because I do have a question about not the media that's been involved from the beginning, but new players that are coming in. I come from a perspective as a nurse who has been lied to multiple times about, yes, I'm a relative, HIPAA doesn't apply to me, and you have to be careful. Oh, well, and I learned over the years to ask a probing question. Oh, well, I don't know the answer to that because I'm not really a relative, and you could discern that. However, I guess I'm concerned about something that is unknown to me, because I don't think that way, of a character that might utilize that benefit for a negative purpose.
I understand that, and I think that, I mean, it is a valid concern, one that I've heard many times. If there is someone specific that you're worried about, my advice would be have the board adopt its policy sooner rather than later, so that you are not in that position of having to single people out. If I would even, again, I would want to participate in drafting that policy. But in my opinion, if someone has, if your policy defines who is media, and one of those people who attends violates the right to the board's confidentiality, in my opinion, you can exclude that person going forward. But again, you have to be very careful about that, and it would depend on the circumstances. So first of all, be sure that your concern is real and not just something you're imagining. If it is real, the best way to deal with it is by policy. And then from there, you enforce your policy consistently. And that's about all you can do, given the fact that the default is always going to be public disclosure, okay? So there are ways to manage it. It isn't going to be foolproof, but I have lots of local government clients. Very, very, very rarely have I seen this become a problem. So I don't think it's as big a concern as it might feel like it is, but I don't know any specific circumstances that you might be concerned about. If you have specific circumstances, then let's adopt a policy to make sure that you can manage it when it happens.
Okay.
Okay.
Eileen, you may be covering this. This is a little bit of an aside, but since you've mentioned the drafting of policy, I'm curious, it's really tough to draft a policy in a group. Policy by committee is not the most fantastic thing to do. Is it okay? Like, how does that usually happen? Can I bring a policy, like a proposed policy, to a public meeting? That's what we've been doing. And we circulate a draft and then people just discuss it and we edit it live during a public meeting. Is that okay to do? Or is it usually the manager that's bringing a public policy to the table? Or how do you usually pull that together?
Well, again, it varies. You can certainly do it the way you're talking about, but it will be time consuming depending on how complicated the policy is. If it's one paragraph, then bringing it to a meeting and having everybody, wordsmith it, it might be feasible. If it's multiple pages, then I wouldn't recommend doing it that way. A couple different approaches. The most typical approach that at least with my clients, is that the board will say, I think we need a policy dealing with whatever, and the board agrees, yes, we need a policy. Let's direct Skylar to draft something. Or
Okay.
let's direct somebody to work with our legal counsel on drafting that, or whatever, so that all the drafting piece of it happens outside of the board meeting. And then it comes back to the board for review and comment and tweaking and so on.
Gotcha.
And then that's much more efficient and usually end up with a better policy as a result. So
Okay.
that's usually the most efficient. If it looks like it's going to be something fairly complicated and a lot of people have a vested interest in it, you also can create a drafting committee of the board or staff, or board and staff.
But the
to go
drafting
and
committee would then hold public meetings again, right? As they do their work, because that's an assignment from the board.
Well, very likely, yes.
Okay.
Yeah. One of the nice things about delegating it to staff is that the staff can do it outside of public, scrutiny, and then come back to the board for the scrutiny.
Yeah. Okay. Thank you.
You're welcome. Okay. All right. Can a board call an executive session whenever it chooses?
In a properly notified public meeting.
Well, and whenever it chooses, probably yes, but for whatever it chooses is a different question, right? There's only specific purpose.
Very well, very, very well answered. You are right. It's a little bit of a trick question. Whenever, sure, whatever time is in your meeting notice, midnight, Saturday. If you want to make sure nobody comes, call it at midnight on Saturday. But you raise a very good point, which is you can call an executive session whenever you choose, but you can only call it for certain reasons. So, and I find this kind of interesting for anybody who enjoys reading statutes, if you're that sad. This is what the statute says. First, it says all meetings of the governing body of a public body shall be open to the public, and all persons shall be permitted to attend any meeting except as otherwise provided by, and then you get this range of statutes right here, 610 to 690. And then this says a quorum of a governing body may not meet in private for the purpose of deciding on or deliberating toward a decision on any matter except as otherwise provided in. And then you get this whole range of statutes, which is the same as that. So it's two paragraphs that say pretty much the same thing, which is you can't meet privately unless these statutes say you can, okay? And Celeste is exactly right in that there are very specific reasons why a board can go into executive session. If it's not one of those reasons, then you cannot do it. You just can't. There's not whenever it seems like a really good idea, or whenever we're terrified of the public, or whenever we are embarrassed. You don't have the authority to do that. However, there are plenty of opportunities to meet privately when necessary. So I'm going to walk through those with you in a second. You have to give notice of an executive session. The notice should state the statutory authority for the executive session. So depending on the reason, there is a specific statute that authorizes that executive session, and your notice should say what that statute is. And then the board chair should also include that statutory authority when he or she convenes the executive session, and then that should be recorded in the minutes. If you've done those things, you've done everything you can to make sure that the meeting notice is complied with. Now, I often get the question, what if we realize that we need an executive session after the meeting notice has gone out? That's okay. Just make sure that you do this step, this bottom one, prior to convening the session. The board chair is still going to convene the executive session, and you still have to have the appropriate authority recorded in the minutes. It's okay to do it at the last minute, not recommended, but if you have to do it, you can. All right. So
So just to be clear, Eileen, can I ask for clarity? Like, so if something were to happen, unfold during a public meeting, let's say we found something having to do with a staff, for instance, that was, arose during a public meeting, but was really important to get on top of quickly. Would that be an incidence where the chair, for instance, could call for a last minute executive session?
Yeah, you definitely can. Again, as long as you have as long as it's authorized, and then just cite the authority for the executive session. Okay.
I was gonna say, I think it would be that we could amend the, if we had an advertised legal public meeting with an agenda and we move to amend the agenda to include an executive session for the stated purpose, which would be correct, that we could do that.
You certainly could do it that way too. Absolutely. Yeah. Again, it kind of depends on how big of a panic are you in. If you know about it before the meeting starts, then I agree. Amending the agenda is a good idea. If it comes up in the course of the agenda, the board chair can decide the best approach, just to make sure that you have the authority to do it and that you've recorded the authority. All right, I'm going to go through these fairly quickly, and these are the most common ones. There aren't that many. There are a couple I left out because they would not apply to you, but these are the ones that come up most often. Considering the employment of a public officer, employee, staff member, or individual agent. This is considering the employment, meaning, let's say Skylar decides to go work for, oh, I don't know, the federal government, and you need to replace the CEO. Okay, the board can, to some extent, have those conversations in executive session if as long as you've done some, jump through a few hoops in advance. One is you advertise the vacancy. Two is you have hiring procedures adopted, meaning you have set forth a process by which you will advertise, hire, interview whoever it is who's filling this job. If it's a management level person, and usually that's the board is the one that's going to be handling that, the public has had an opportunity to comment on the process, including the job description. And then this final one is the hiring criteria and procedures were adopted in a public meeting after you've heard the public comment. So the idea being that all this transparency happens ahead of time, and if the public is aware you're going to do this and they have been able to comment on the process, then it's appropriate that the board can go into executive session to interview the person, discuss the person. The person doesn't even necessarily have to be there. You can discuss, various candidates, and the board can do all that privately. The only thing you can't discuss in executive session is compensation. That always has to be discussed in public. Okay, now the process does not apply to the filling of a vacancy in an elected office. Now, I have seen this come up in it's hard, but it's true. You have a board vacancy, and you have one board vacancy and 3 people who want to fill it. And you have strong opinions about those 3 people. The question comes up, well, shouldn't we be able to discuss that in executive session? So, because we don't want to hurt anybody's feelings or have them get mad at us or whatever. And unfortunately, no. If you have filling a vacancy in an elective office, it's required that you do it openly. There's no executive session authority to do that. That also includes, I've had a board ask if they could maybe just write down their preference on a piece of paper and submit it to the board chair and have the board chair decide. And that's a secret vote, and no, you can't do it that way either. So you got to take it on the chin for this one. And it's hard, but that's the point. And again, this gets to Sue's earlier question about, well, I was appointed, I wasn't elected, and do I have all the same obligations and duties and responsibilities as an elected person? Yes, you do. And that's, this kind of feeds into that. This is all going to be part of the public process. The public is going to hear the process. They don't get to decide who fills the job, but they get to certainly sit in on the discussion about who's going to be doing it, okay? Similarly, with vacancies on committees, like your budget committee, that kind of thing, if the board is making that call, that all has to be discussed in open meeting. General employment policies, if you're adopting, an employee manual or amending it or adopting a new policy that applies to everybody, That's a policy decision. That's not a personnel decision, and that needs to be discussed in public session. And then if you haven't met all those earlier requirements, then the discussion about who you're going to hire to fill your chief executive officer or other staff position, that's must be done in public session as well. Oops. All right, this one comes up fairly often. Considering the dismissal or disciplining of or hearing complaints or charges brought against a public officer, employee, staff member, or individual agent who does not request an open hearing, and similarly, or to evaluate the employment-related performance of the CEO. So these are kind of specific, these relate to specific individuals. This first one, somebody from the public, someone from another staff member, somebody is complaining about a staff member. Even though this says public officer, this does not mean board members, okay? This means staff or a volunteer, okay? It does not include elected or appointed, people appointed to elective office. So if somebody is complaining about staff and you want to go into executive session to talk about that or meet with that person, you can. Similarly, you can evaluate their employment. So you're going to do an evaluation of Skylar's performance in executive session. That's okay to do that. In both of these situations, the person being complained about or the person being reviewed has the option of having it be done in open session instead, in which case you have to do it that way. So the default is executive session, but the person that you're reviewing has to be told that you're going into executive session because they have the right to say, no, open session's fine, in which case you have to do it in open session. I've seen it go both ways. I've seen the individual being evaluated does not want their dirty linen aired in public and they would prefer to stay in executive session. I've also seen the person being evaluated say, wait a minute, this board is railroading me and I'm being hung out to dry. I would like to have this be done in open session, and that's their right to have that call be made, okay? Those are separate executive session authorities, but they're similar in their content and the process that you use. You can meet in executive session to talk with whoever's doing your labor negotiations. Do you guys have a collective bargaining unit?
No.
I didn't think you did, but you might. Some districts have some who do certain things and others who don't. Okay, if you did and you wanted to meet with your labor negotiator, you can meet with that person in executive session. Similarly, the person who is negotiating a real property transaction on the district's behalf, whether that's your manager or a lawyer or your real estate agent, whoever it is who's negotiating on your behalf, it makes sense to meet with them in executive session because that should all stay confidential until the deal is done. Because tipping your hand can make the process go south. If you wanted to meet with someone about your public investments, I've never seen that happen, but if you wanted to do that, you could. Considering information or records that are exempt by law from public inspection. When we get to the public records unit, we're going to talk about that there are certain public records that are allowed to be kept confidential and not disclosed upon request. If it is legitimately appropriate to not disclose a public record, it's okay to discuss that public record in executive session, which makes sense. If it's a confidential public record, it would defeat the point to have to discuss it openly. Okay, so if it meets the public records confidentiality requirements, then there is a executive session authority to talk about it there. All right. This next one is meetings with your lawyer. It is a common misconception that anytime you guys talk about legal matters or anytime you meet with your lawyer, that can be done in executive session. And unfortunately, that's overly broad. You can meet with legal counsel in executive session to discuss litigation filed or likely to be filed. So somebody's going to sue you and they've told you, or you're going to sue somebody and you've told them, or you are in the middle of some kind of litigation. You can meet with the lawyer or legal team who is handling that litigation in executive session. That's okay to do that. However, if you just kind of want to get advice from your legal counsel generally, and you're not suing or being sued, there is no executive session authority to do that. The easiest way to get around that, if the board wants to discuss a legal matter, is going to be this, which is communications, written communications from your legal counsel are subject to attorney-client privilege. So they are not disclosable public records. The board does not have to disclose them upon request because they are privileged. Now, having said that, if you ask your lawyer to send you a memorandum explaining your rights and duties with respect to issue B, and you haven't sued and you don't intend to sue and nobody is suing anybody, it's okay to go into executive session to discuss the legal advice that you're getting from your lawyer, as long as it's in writing. So if the board wants to get legal advice from your lawyer outside of an executive session and it is not related to current litigation, ask your lawyer to write it down, submit it to the board. The board can discuss it in executive session and deliberate about it and that advice. The lawyer does not necessarily have to be there. It's nice if he or she is, but they don't have to be. In this example, the board member or the lawyer must be there, either in person or on the phone or virtually, okay?
So Eileen, can I ask a question?
Sure.
So some of the previous slides reference more like performance of, staff. But let's say, for example, there's an investigation on like some sort of misconduct that, for example, like maybe you led an investigation or somebody else did. We could then potentially take the recommendations that you've given us in writing and review those in executive session then.
Very likely, yes. Under this, first of all, if it's from me as the district's lawyer, it's going to be privileged, and the board can decide whether or not to disclose it. So that's definitely yes. There also is, when we get to public records, you'll see this, but there's also an exemption for investigatory information.
Okay, I was wondering about that.
Yeah. And we'll talk about that a little bit more when we get there, but that's a good point. Like if you're, let's say OSHA's investigating, or the Attorney General, or I don't know who else would be, workers' comp investigations, all of that information is exempt from public records disclosure, at least until the matter is decided or resolved.
Okay.
So while the investigation is ongoing, the board can talk about the documents in executive session because they are exempt public records, okay? So whether or not they're from a lawyer. Similarly, if a lawyer does the investigation or the lawyer gives you advice about it and writes it down, you can also talk about that in executive session, okay? And all of these you'll see, my sense is always, there is a common sense business related reason why you would be able to discuss this stuff privately.
Right.
Whether it's to protect privacy of somebody else, or to preserve the district's advantage in a deal, or something like that. But it makes sense that while an investigation is ongoing, that is not public fodder until it's resolved, okay? Meaning that somebody should not be unfairly impugned until you have concluded an investigation. Does that answer your question?
It does. It kind of makes me wonder about the media's involvement. Again, I guess that has to remain confidential. I just think when you get into kind of employment related concerns, I would worry about some of that being out somehow and then us being sued for that, because do you see what I'm saying? When you don't have full control over, I guess, some of the media attending.
Well, if a member of the media were to disclose something that they shouldn't have, that is generally not going to be a liability of the district.
True. Okay.
If you had no control over that, then I wouldn't be overly concerned about that. Your responsibility is to preserve confidentiality to the best of your ability. And if it's not your fault, then you can't really be held liable for it. But
yeah, okay.
Yeah. And there may come a point, and I've seen this happen actually in a district that I represent in your area, where they have their intrepid reporter who comes to their executive sessions, very reliable. I have no issues, and as far as I know, my clients don't either. But takes very good notes on documents that are discussed in executive session. And as soon as that puppy is resolved, we get the public records request. You know, I would like to see documents related to blah, 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 because that person knows the law. And under that situation, there may come a point when stuff has to be disclosed, but usually not while the investigation is ongoing. Okay, this probably won't apply much at all to you. This is various types of special districts offer certain kinds of services, water, sewage, et cetera, et cetera. This was something that kind of interestingly got beefed up a lot after 9/11, where basically the ability for a board of directors to keep information about infrastructure security confidential was enhanced substantially, both here and in the public records laws, just because it made sense that we not tell a terrorist wannabe how to sabotage our infrastructure. So in your case, you know, if you had, let's say you had protective measures in place for your telecommunication systems, your data transmissions, you know, whether it's passwords or security systems or whatever form you have to protect your communication grid, I would argue that this very much gives you the opportunity to not disclose that upon request, just because you don't want to let anybody into your, give somebody a pass into a way to sabotage your communication system. Okay, penalties, public meetings law. And again, that was pretty much it for executive session. So if you didn't see your opportunity there, it probably doesn't exist. But if you fail to comply with executive session laws, that's considered an ethics violation, which we're going to talk about, assuming we have time. Let me just check my watch here. Yeah, we'll hurry. We're going to rip through public meetings because it's pretty quick to convey most of that stuff. Public records, sorry. It's an ethics violation for elected officials, board members to violate executive session laws, meaning that you are personally liable under the ethics laws. So the penalty will come out of your pocket, your insurance, the district's insurance will not help you with that. And then the maximum fine for executive session violations is $1,000 per violation, but it's excused if the decision is made in reliance on advice of the public body's legal counsel. So, yeah, we won't get into the intricacies of that, but it's a good idea to get legal advice if you're concerned about that, because you can often, you may be held liable, be found to have violated the law, but there won't be a penalty associated with it. Okay, that was public meetings. Before I get into public records, are there any lingering questions on what we've covered so far? You guys have great questions, and I can tell that many of you have been paying attention to prior trainings, and that's great. Okay, learn from each other, but learn the right things from each other. Okay, we're going to talk about public records. Again, this is not something that the board is probably going to get too involved in, so I'm not going to spend a lot of time with the board. This is something that's important, however, that the staff understand, because they're usually the ones getting the requests. And I also find it's helpful for the board to understand the basics of the law, so that if somebody comes to you and claims that you have to do this and you have to do that, and why aren't you doing this? It's helpful to be in the seat of knowledge on what it is that you are required to do and what it is you're not required to do as a district. The administrative components of it are likely going to fall to the staff, but the policy pieces of it are the board's responsibility. So we'll talk about those. All right, public records. There are a lot of parallels between public meetings and public records. They're both part of that whole transparency objective in Oregon. We're going to talk about the application of the law, disclosure requirements, exemptions from disclosure, and then a little bit about retention. I'm going to admittedly go through fairly quickly because I want to make sure that we get to ethics, because that applies to you guys directly. But stop me if I start hurling spit and you've lost track of what I'm saying. Okay. When we talk about public records, here's the definition in the statute. Any information in any form capable of retention by a custodian that relates to an activity, transaction, or function of a public body and is necessary to satisfy the fiscal, legal, administrative, or historical policies, requirements, and needs of the public body. That is just a classic example of statutory overkill. So what you should take from that is everything that the district has is a public record. Assume that, okay? If you can send it, mail it, email it, photocopy it, put it on the wall, assume that it is a public record, and it must be treated accordingly, okay? Here's what the public's rights are in public records. Every person has a right to inspect any public record of a public body in the state, except as otherwise provided. This is familiar. You see this range of statutes. These are the exceptions, which we're going to talk about. So they have the right to inspect. That's the public's right. Just as they have the right to attend and listen, they have, legally speaking, a right to inspect public records, okay, unless an exemption applies. They don't have a right to order you around and demand certain things and, you know, make sure that you do it the way they want you to do it, etc. But they have the right to inspect, and you have to set up processes that allow them to do that. I'm going to skip that second paragraph, but if you read this later and have questions, let me know, because it's very specific. Okay. A request for public records may be denied if the person making the request is just trying to create hassles and cause trouble. Is that true or false?
False.
False. Very good. Unfortunately, for some of us, that is true. That is false. Motive doesn't matter. Okay, it doesn't really matter. I often hear, well, they're just on a fishing expedition. They're just trying to dig up dirt. They're just trying to make my life miserable. Yes, that may very well be true, but it really doesn't matter. Okay, but what I'm going to tell you is that if the board and staff have a process in place for managing public records in a way that is legally compliant, you don't have to feel like you're being beaten up by it. All right, you don't have to reinvent the wheel every time. You have a process. Everybody goes through the same process. You treat everybody the same, and hopefully you get staff in the habit of knowing how to do it, and it happens like clockwork, and you don't end up having to continually deal with the accusations from somebody who thinks you should be doing something differently. Okay, every public entity is required to have a public records custodian. You don't have to call them that, but it's essentially at least one person whose job it is to sort of railroad the public records. They keep them safe, they make sure they don't get damaged or stolen, and then they furnish proper and reasonable opportunities for inspection and examination of the records in the office of the custodian, and reasonable facilities for making memoranda or abstracts therefrom during the usual business hours. So there's a lot in that, but that's a statutory requirement. So notice that you have to provide an opportunity for inspection and examination. You are only required to do it in the district's office. You don't have to go anywhere. You don't have to mail anything. You're required to do it in the district's office. And you provide reasonable facilities for them to view the documents, take notes, make copies during business hours. Okay, so when you go to adopt your policy, it's going to say all that. It's going to say, and I haven't seen yours, so it may already do this, but a good policy is going to say, here's what you guys get to do as members of the public. Here's the process you need to follow. Here's where you can inspect them. Here's when you can inspect them. These are the hours that you can inspect them in. And then we're going to talk about fees and charges in a second. Now, if the record is maintained in a machine readable or electronic form, this was a relatively recent addition that sort of acknowledged that email is a thing. You must furnish proper and reasonable opportunity to assure access. This does not mean you let somebody sit down and scroll through your emails and find things that they want. You can certainly forward emails to someone if you choose to do it that way. You can copy them out and have them come and look at them. But basically you need a process whereby you can share electronically stored documents. And the custodian can adopt reasonable rules to make sure they stay safe. You never give away, never send documents away to somebody to leave for the weekend and bring them back on Monday. Don't let them leave the premises. Make sure they don't get damaged or stolen or are left unsupervised at any time. Okay, in terms of what you are required to do when somebody makes a request, you're required to respond as the old law was as soon as practicable and without unreasonable delay. This was very broad, and unreasonable was a constant subject of debate. That was changed in 2018, so now you have 5 business days to acknowledge the request, and then once you've acknowledged it, you have another 10 days to either fulfill it or tell them why you can't. But there are time limits now associated with that. You can extend the time if you need to clarify or you need additional information. If, let's say, for example, the document is available electronically, like on a website or elsewhere, you can refer the person to that location, and that is as good as compliant. Blah, blah, blah. Here we go. The public body is not liable for any damages if a record is disclosed that is not expressly required to be kept confidential. So there are protections in the law if you disclose something you weren't supposed to. So don't be overly concerned, just be very careful as best you can. If you fail to respond within the timeframes, it's considered no response, which enables the requester to take the next steps to enforce the request. So when you get the public records request, you acknowledge that you received it, you ask for clarification if necessary, and then you provide one of the following responses. And they're all listed here. It's all in the statute. You can say you don't have it, you're not the custodian of it. You might have some of them, and you give an estimate of time of when and how much it's going to cost. You don't know whether you have it, but you'll look into it, and you give them a date about when you will be able to respond. Or state or federal law prohibits you from acknowledging whether you even have it or whether it exists. That's a weird one, but I'm guessing it's there to comply with HIPAA. Because under HIPAA, you can't really even say whether you have documents or not that fall under the law. You provide a copy in the form it's requested if available. The public records are the records that you have. You are not required to recreate them in a different form if you don't keep them in that form most of the time. You make it available in the form in which it is maintained. The public does not have the right to demand that it be done, that I would like a report and I would like it done in Excel format and I would like it to include the following reports and yada, yada. That is not part of the public records law. You could do it if you wanted to, but you don't have to. If you get something that's subject to attorney-client privilege, a request for attorney-client privilege document, usually that involves litigation that is ongoing. There is a provision that says you prepare a condensation of the facts and you don't actually disclose the privilege documents. If a citizen asks for written minutes of a meeting to be transcribed onto an audio tape, are you required to do this? And I put it in the form of a question, but the answer is generally no. You are not, unless you are doing it to accommodate a bona fide disability. In which case, you can provide it in that format, and if your rules allow for it, you can charge for that alternative format. Okay, every public entity is required to have a written public records policy. It must at minimum include the name of one or more persons to whom requests may be sent with an address. Doesn't have to be could be a job title, doesn't have to be an individual person, but there should be a point to whom one directs a public records request, and then include the amounts and the manner of calculating fees. You can charge fees to recover your costs, and they have to be reasonable, and they should be designed to recover your cost and not to gouge the requester or make a bunch of money off public records requests. So you can recover the cost for, I'm going to back up a step because I'm just going to talk for a sec. You can recover the cost, actual costs like copying costs, paper costs, staff time for the amount of time it takes to locate the records, assemble them, and make them available at the employee's regular hourly rate. And you can also include, if the request includes documents that may need to be exempted from disclosure or redacted from disclosure, and you need a lawyer to help you do that, you can pass on the cost of the lawyer's time to the requester. Not just for general legal advice, but for the time it takes to sort of sort through what's exempt and what's not exempt. So, but all of this should be in your policy, because in order to charge the fee legitimately, it should be in your policy. If it's going to be more than $25, the law requires you to provide them, the requester, with written notification and have them confirm that they want it. I like to see these regardless of the dollar amount. Some estimate that and provide it in advance and require them to pay for it in advance, so that you don't end up generating a bunch of documents that they decide they don't want at the last minute. Okay. If you are going to waive charges for anyone, do it as a matter of policy and not because you like somebody or don't like them. Have a policy that says when you will waive the copying charges. Could be for the media, could be for nonprofits, could be for other governments, but the board should decide when or if you will waive the fees. And then I also, these are my recommendations, they're not necessarily required, but I like to see requests be done in writing, particularly if they're complex, so that you have a paper trail. Include the times and days when inspection is permitted, describe how you will calculate the fees, that's part of the requirement. List considerations for waiving or reducing fees. Post the policy, meaning put it on your website, post it physically wherever it is people are likely to see it so they know that is your policy. Apply it uniformly to everyone. The best way to get yourselves into legal trouble is to be arbitrary about how you apply your policies. And if in doubt, get legal advice. And you have the authority or the time built into the statute to allow you to do that. Okay, exemptions from disclosure. I'm going to rip through these really quickly. It is likely we will be here till 7:30. Are you guys okay with that? That's a little more than 2 hours. Everybody
I'm
okay
good.
with that? If you need to leave, it won't hurt my feelings, but I want to make sure we get through everything. These are just examples. There are a gazillion exemptions to public records, but here are some that come up most often. If somebody asks you to if you keep their personal information on file, like their address or their email address, that kind of thing, and they have asked you in writing, please don't disclose that because I have reason to believe that I am not safe in my home. And they request that you do that in writing, you must honor it. I recommend taking their word for it. This is to deal with people who might be being stalked or running from bad guys. And in the past, people could use publicly available information to find them. Public employee photo ID badges, emails that you keep that are not district emails, like you keep the emails for your vendors or your contractors or somebody. You don't have to disclose those. Information of a personal nature for such as in a medical file, unreasonable disclosure, documents that would be an unreasonable violation of privacy to disclose them. Personally identifiable information, this is relatively new, but this is getting at trying to preserve privacy for employees and volunteers. So personally identifiable information does not include their name, but it does include their home address, social security number, driver's license number, etc. So the idea being that public employees are entitled to privacy just like any other employee, unless there's a good, compelling public interest reason not to keep it confidential. Certain confidential information, non-financial membership records for PERS. If you were a library, your circulation records would not be disclosed. Documents relating to litigation that is ongoing, trade secrets. This is the investigatory stuff we talked about. Criminal investigatory information, workers' comp claims, OSHA violations until the final order is issued. Personnel discipline records usually are confidential. There may come a point when they are not, but assume they are unless you have gotten good legal advice otherwise. Test questions, scoring keys, real estate appraisal information. I know that came up for you guys fairly recently. Prior to acquisition, it may be disclosable afterwards, but prior to acquisition, you can generally keep that confidential. Names and signatures of employees relating to union activities, endangered species, if that comes up. If you go to dig a hole somewhere and you find a dinosaur bone, don't tell anybody until we notify the proper authorities. I'm going to skip through some of the, okay, that was fairly quick. You may find that when you review those, you have questions, and I am happy to answer those outside of this format. Retention, there are retention schedules that the Oregon State Archivist keeps. They look, if I can show this on my screen, I printed out the applicable one for special district records. Looks like this. These are Oregon administrative rules kept by the Oregon State Archivist that say how long you have to keep records, and it depends on the record. So here's a statute for you to go look that up. If you're inclined to get rid of a public record, just make sure that you have kept it the required amount of time. Make you aware of a couple of things. These are relatively new. 2017 was a big year for public records laws. It established a legislative council committee to review public records laws. The Sunshine Committee is 15 members, supported by the Department of Justice, reviewing public records laws and exemptions and making recommendations for changes. Yours truly is representing special districts on this committee. So I am working, or we did before COVID. We have a 10-year mandate to manage the exemptions from public records laws. So watch this space. And then there is a public records advocates office that was created, who was appointed by the governor. And if you have a public records conflict, the idea is to take it to the advocate to resolve short of a legal action, which can be useful if you need that. Okay, that was public records in a nutshell. And now I'm going to go through ethics in the final 15 minutes we have. Any questions on public records? You got all that, right? Okay, it's not a very sexy topic. It's important. But again, congratulate your staff for understanding how that's supposed to work. Okay.
Mike, I do have a question.
Okay.
If you take notes, for your own, memory, are those considered something that is part of the public record? I mean, if somebody says, I want to see what Celeste Bodner wrote on her paper, is that a public record?
Likely, yes.
But what if
Be
they
careful
what if they can't read my handwriting?
I have never seen it become a big issue, but for example, I have known of like city council members coming to mind who pass notes during the meeting.
Oh,
Those were considered public records that were required to be disclosed. So assume that if somebody really wanted to see your notes, they could, or copy them. Okay, so just be careful what you write in a public meeting. Okay. Now, if you were to go home on your private, private computer, summarize the meeting for yourself, we probably could prevent that from being disclosed, but what happens during the meeting is generally public, unless it's an executive session, okay?
okay.
All right, for the meeting, I need a copy of the agenda, the hidden agenda, and my own twisted personal agenda. We're gonna talk about ethics. Ethics for public officials. We'll talk about the law, disclosure requirements, exemptions from, oops, sorry, got the wrong bullet points. Let's skip that one. That's a copy and paste error. Okay, you may be familiar with the Oregon Government Ethics Commission, OGEC. It's the administrative agency that enforces Oregon's ethics laws. It is a state agency. It's supposed to operate independently. May or may not. But it was created in 1974, and actually it followed the Watergate scandal. I am of the opinion that many states, Oregon probably leading the way, will soon be addressing legislatively some of the loopholes that have come up in terms of government ethics at the federal level. I won't get too far into politics, but there has been some violation going on that we may see legislation to address. Oregon tends to be pretty proactive about addressing issues before they have to. So watch that space. The ethics laws were enacted at that time. So they've been around for a while. They've undergone some changes, but they've been around for a while. If you wanted to go look up the statutes or in ORS chapter 244, and then there is the Oregon Ethics Commission's Guide for Public Officials. If you don't have a copy of that, I recommend getting one. It's often part of public board member orientation. It's available for free if you go to the Oregon Ethics Commission's website. And it is a helpful guide. I find it to be not as helpful as it could be, but it's better than nothing, and it's free. So go look it up. All right, scope of the ethics laws. There is a common misperception I find, particularly among the public, but often among people who serve on public elected boards and appointed boards. The ethics laws are not concerned about whether you're a nice person. Okay, they're not concerned about whether you beat your spouse. They're not concerned about whether you cheat on your loved ones. They're not concerned about morals at all. What they are concerned about is abuse of office and financial impropriety, okay, and lining your pockets improperly. All right, so we're going to talk about economic conflicts of interest, undue influence, use of political office for financial gain, and then the disclosure requirements to make sure that you are complying with the applicable laws. They apply to all public officials in Oregon. So that includes elected officials and appointed officials. It also includes appointed officials, includes public employees. So these laws apply to public employees as well as anybody who serves on a volunteer board, all right? Also includes volunteers. So if somebody's volunteering for the district, some of these laws may apply to them as well. Applies for you if you are a candidate for public office. So you put your hat in the ring to run for the board or rerun for the board, they apply to you while you are a candidate. They also apply to your relatives to some extent. These people, as it's defined under the law to include spouse, parent, yada, yada, the usual sort of relatives, are also can get you in trouble for violating public ethics laws. And it also recently was amended to include first person, which is the spouse or partner of the governor. Can we think of something in the news that might have triggered that? So yes, the governor's partner is included. And also anyone for whom the public official has a legal support obligation, which is kind of legal speak for saying someone who is living in your house that you're supporting that you might not be related to. Okay, that's generally who that means, or might benefit financially. I always think this might be like the mistress exemption here, but nobody has explained that to me. All right, ethics in employment. Can you hire your relative? No. The public official can't participate in employment decisions regarding relatives. So if one of you has, if it comes time to replace Skylar and one of you has a son or a daughter or a niece or a nephew who wants to put their hat in for the job, you would have to recuse yourself as a board member because you can't participate in that process. Similarly, public employees can't supervise members of their household or their relatives. There are two exceptions to that. The class exception, meaning that the action that you're taking, let's say the board is going to be approving a new benefit package that's going to apply to all employees, and your daughter works for the district and she will benefit, but she is part of a larger class. That's okay. You can do that without having to recuse yourself.
So I mean, if my daughter was still employed by the district and I was on the board, that would be a problem, right?
Not necessarily. You can't be in a direct supervisory relationship with her, okay? So, and you probably wouldn't be, that the manager would be supervising her, correct? And if you are making decisions that benefit the employees generally and not just her, that's not considered a conflict of interest. However, if there's an opening, a staff position open, and you come and say, my daughter would be excellent for this job, I want you to interview her, and these are her salary demands, and you start intervening on her behalf specifically, that's an ethics violation, okay? So as long as you're handling it at a policy level and not at an individual level, you would be fine. That make sense? You also can't advocate, if your daughter is the only one in the communications department, you can't propose a policy where everyone in the communications department gets a 50% raise because it's going to have the effect of benefiting her directly, okay? Generally doesn't apply to unpaid volunteers, not including board members. We'll cross that bridge if we get to it, but for the most part, if the person is not being compensated, you don't have to be too concerned about supervising them. You can't provide a reference, you can't provide a recommendation, that's fine. You can't directly supervise them. Okay, so that's employment. And then financial gain, which is kind of the pith of these laws. The but-for test is you cannot use your official position to obtain a financial gain, so make money, or avoid financial detriment, i.e. save money, if that opportunity would not be available but for your position on the board. So this is what we call a bribe. This is where if somebody comes to you and says, you know, Michael, I love the work you're doing there. I'm going to be coming to you later for a decision, but you guys are awesome. So I'm going to give you a free haircut. And the only reason they're doing it is because you're on the board. Yeah, beautiful. And they did a good job. The but-for test measures that. Would you be getting this if you weren't on the board? And if the answer is no, then it is very likely an ethics violation. Okay. This applies to the public official, a relative of the public official. So, you know, your wife's free haircut, your mother's free haircut. You know, if they're still in the kitchen, tell them they can't get a free haircut because you are on the board. They can get a free haircut, but.
Is there a statute of limitations on that?
Depending on the circumstances, once you are off the board, it probably does not apply. But if you are a candidate, it does. So if you leave the board and they just want to give you a free haircut, just thanks for your service, here's a free haircut, that's probably fine. We're going to talk about gifts in a minute and the parameters around that. Also, if you have a business outside of, you know, this work that you do on the board, you can't engage in an activity that's going to benefit your business uniquely. All right. These are examples of unlawful financial gain. Some of them will apply to employees who are also subject to these laws. Using district equipment when the public does not have the same access to the equipment. So, you know, the district keeps, you know, wood shop tools or vehicles or storage space. And hey, I'm on the board, I'm going to use this stuff for free. Or I'm an employee, so I'm going to use this stuff for free. That is considered an ethics violation because it's not available to the general public. Free use of district facilities like meeting rooms or swimming pools or whatever amenities are being offered. If it's being, I had somebody once, actually a park and recreation district that operates a swimming pool, and they wanted to honor a longtime board member with a lifetime pass for swimming, free swimming. And we ultimately concluded that that's not going to work because essentially, it was a violation of ethics laws. We ended up working around it, but I won't get into the particulars of that, but it was a problem. Buying meals, waiving entry fees because you are a public official, that is an ethics violation. Don't accept free stuff if you can help it. Employer provided cell phones for personal use, frequent flyer miles earned on official business may violate the law. Discounts, there are ways around that for employees, but anytime somebody's offering you a freebie because you're on the board, your little spidey senses should go off. These are not considered unlawful financial gain, so these are okay. Official salary and benefits, employees can be paid and receive benefits. Unsolicited honoraria under $50. So you do a speaker's fee and they say, well, here's $49.99 for your time and trouble, that is going to be okay. Or if it's related to your private employment. Reimbursement of expenses. So board members can be reimbursed for expenses and it's not considered a violation. Unsolicited awards for professional achievement. So this is where if an employee is going to be given a gift certificate for a night out because you're employee of the month, that's fine. Gifts under $50 from a source without an administrative or financial interest in the public official or the entity you represent. I know this is going to get a little bit boggy. This is the nature of the laws, but hopefully you'll flag a few things. Now, when we get into gifts, there are a couple things to keep in mind. You cannot receive a gift valued at greater than $50 from someone with a legislative or administrative interest in the public body. So notice all the criteria. And a gift is what you expect a gift to be, something for free that you are not paying for. Now, legislative or administrative interest in the public body. This means that with respect to the district's board of directors, can the person who's offering you the gift sell something? Do they want to sell something to the district? Do they want to submit bids? Do they want you to give them permission to do something officially? Do they want to advocate for some kind of outcome, like lobby you for some sort of legislation? Will they be affected by employment decisions that you make? If they are in a position to benefit from a decision you make on the board, then they have a legislative or administrative interest in you as a board member. So that criterion having been met, the limit is $50. So if they have a legislative or administrative interest, I'm pointing at the screen like you guys can do that. If they have a legislative or administrative interest, they could give you a gift, but it would be a really cheap, crappy one because it can't be valued at more than $50. And that's $50 per individual per year. And you are responsible for keeping track of that. So first of all, don't get in the habit of accepting gifts from anybody for any reason, but these kind are illegal, blatantly illegal, and don't just look bad in the eyes of the public. Is entertainment a gift? Yes. If they invite you to an event or an activity, you know, the Blazer game exception, the Blazer game number was kind of the common one. Let me take you out to a Blazer game for $500 because you are lobbying for my interests. That's the traditional example. But if they want to take you out and schmooze you because you were on the board, it is still improper schmoozing if it's entertainment of any kind of value, or if it's provided by someone with a legislative or administrative interest. Same logic applies to food and beverages. They want to take you out for dinner, or they want to give you a gift card to go out for dinner, whether they're there or not. If they have a legislative or administrative interest, they can't be for more than $50. There are exceptions if you're at a reception. When it's an incidental part of the reception, you don't have to calculate the value of your pigs in a blanket and decide whether you have exceeded the minimum. It's okay to eat the reception food. Similarly, if you are representing the district, like let's say you go to the SDAO conference or the Parks and Rec conference, and you are representing the district, it's okay to eat the food and beverage that's being offered and not have to worry about it being an ethics violation. These kinds of gifts are okay. Gifts of any kind of value if they don't have a legislative or administrative interest in the public entity. So somebody gives you a birthday present or a Christmas present or wants to take you out for lunch because you're just fabulous and they don't have an administrative or legislative interest in you, that's perfectly fine. Or they have a legislative or administrative interest, but the gift is under $50 or $50 or less. So they want to give you a cheap and crappy gift. They want to buy you a Happy Meal. That's probably just fine. Looks bad in the world of public opinion, but technically not a violation of the law. And gifts that bear no relation to your public position. So people who don't care that you're on the board, that's fine. They can buy you gifts. Subscriptions, that's some sort of minor stuff I won't get too far into here. Well, I'm going to skip that one too. Unsolicited awards of appreciation with a resale value of less than $25, like a plaque. So they can give you an engraved plaque to express their appreciation as long as you didn't ask for it and as long as it's crappy and it doesn't cost more than $25. And I always wonder what the resale value of an inscribed plaque is anyway. You know, I guess if you're famous or infamous, it might have some resale value, but okay to accept a small or modest plaque. Also an honorarium of less than $50, reasonable, you can get your reasonable expenses paid if you are there in an official capacity. So the district can pay for you to go to the conference if you're representing the district, that's fine. Contributions to your legal expense trust fund, if you have one of those. I hope you don't, but if you do, you can accept contributions to that. Okay, undue influence. You cannot solicit or accept the offer, pledge, or promise of future employment based on any understanding that a vote, official action, or judgment would be influenced by the offer. So it's one of these where, you know, I promise to hire you when you leave the district if you do this thing for me. That's undue influence. Using or attempting to use confidential information gained to your position as public officials for financial gain. So you can't, this is the insider trading rule. You can't use that if it's going to make you money. A direct beneficial interest in a contract. So let's say you're on the board and you approve a construction contract while you're on the board, and then you leave the board and go to work for the contracting company that for whom you approved the contract. That's a violation. You have to wait 2 years until after you approve the contract to take advantage of that windfall. Future employment, oh, we touched on those as repeats. Okay, now conflicts of interest. There are 2 types of conflicts of interest under the public record, I'm sorry, the ethics laws. One or both may apply. The first is a potential conflict of interest. That means that it hasn't really ripened yet, but the decision that you are going to make as a board member, once made, could result in financial gain or avoidance of a financial detriment. So in the example, let's say you own a piece of property or land, and you own it personally, it's your land and it's undeveloped. And the district is looking for land on which to build something. And they've narrowed it down to 3 parcels and one of them is yours. So Skylar comes to the board and he says, we've got 3 parcels. I just need approval to pursue these 3 parcels and do some due diligence. At that point, Catherine, let's say you own that piece of property. You would say, I own property A. I have a potential conflict of interest. So I'm going to disclose that for the record because I own that. You can still discuss it. You can still take votes at that meeting because your conflict of interest is only potential. So your obligation is to disclose the potential conflict. You don't know for sure that you're going to make the money, but you could. So you disclose it. And that's all you're required to do as long as there is a public disclosure on the record, you have complied with the law. Okay. Now, let's say that same scenario that Skylar did all his research, he comes back and says, okay, the parcel A is the best one. It's the best price, it's the least amount of work, it's in the right location, yada, yada. I would like a recommendation from the board that we make an offer on parcel A. Okay, at that point, Catherine's conflict of interest is actual, okay? She can't participate in this because if the board approves this, she's gonna make some coin off of this decision. So at that point, she has an actual conflict of interest. She can't participate in the conversation. She cannot vote. She doesn't have to leave the room, probably, but she has to disclose for the record, I have an actual conflict of interest. I own parcel A, and then she just abstains from any further participation, okay? And as long as she's disclosed it and doesn't participate, that's all that's required. Remember that the ethics laws are primarily, they have to do with financial gain and avoiding it, anything that looks like a bribe. And they also have to do with public disclosure. The public wants to know what your dealings are, and if you have a conflict of interest, you must disclose it. You're not prevented from having a conflict of interest, you're prevented from keeping it secret, okay? So that's the main thing to keep in mind in terms of procedure. Now this is a new addition. Again, I mentioned that the legislation, what happens on the federal level, we will often see reflected in our local legislation. There was a new law, a new amendment to the ethics law enacted in 2019 that prevents a public official from using public funds or funds from third parties to make payments under a non-disclosure agreement relating to workplace harassment, including sexual harassment or sexual assault by the public officer while in office or when a candidate for office. So non-disclosure agreements, you're going to make payments to hush money essentially, okay, but you can't use public funds to do that, okay? If anybody's planning on doing that, save up now in your little bank account. Okay, penalties for ethics violations. The maximum penalty for most of them is $5,000 per violation. And again, the tail is 4 years. Those high ones are usually reserved for egregious and intentional violations. Again, if the executive session violation, it's up to $1,000, but excused if you relied on advice from legal counsel. Okay, and also if you financially benefited, there can be a civil penalty in an amount equal to twice the amount that you gained. So you made money off this deal, fork it over plus some. Again, no penalty if you relied in good faith on the ethics manual or the ethics commission opinion. So they're looking for intentional violations or gross negligence where you didn't even try to find out what the law was. And then there was a relatively, or actually new, this was 2019 as well. It used to be that if the ethics commission pursued a claim against you, and you were found to be innocent, then the Ethics Commission had to pay the attorney fees. They have since changed that in 2019 to say, well, you can ask the court to get them to pay that, and the court gets to decide, but only if there is no substantial justification for pursuing the claim, and only if the award is not unjust. So basically, if there's anything there to justify the action, you're not going to get your attorney fees paid, unfortunately. Okay, how'd we do? Oh, damn it, kept you too long. Sorry about that. Okay, for anyone still remaining and wanting to stay remaining, I am happy to entertain questions if you have them based on what we've already talked about. And if you have to leave and want to leave, it won't hurt my feelings at all.
Guys, I have to go. I'm the only parent tonight, so I should.
Been there.
Yeah, I should go do what I need to do there. But thank you so much, Eileen.
You're very welcome. Good to
All
see
right.
you.
Bye.
Sue, Mike, or Celeste, questions?
Go ahead. I just wanted to thank Eileen and Skylar too for arranging this training, and it's very useful for all of us to stay acquainted with these rules and be compliant. You know, it's pretty easy to do as long as we work together as a board.
I agree. The fact that you guys are here says a lot about your willingness to do everything by the book and correctly and cooperatively, and that is wonderful to see. The people who need the training most often don't get it.
Thank you.
Eileen, I want to thank you too. I think one of the hardest things, at least from my perspective as a board member, is, well, you know, I had reviewed a lot of this information. It is a little bit tough when you have members of the public accusing you of violating pieces. And I've seen some of my fellow board members really struggle with that. And I think this has brought a lot of clarity to the fact that as a board, we are doing our full due diligence. And I'm really proud of our group because this is a very engaged board from my perspective.
I hear you, and it can be, and again, like I said in the beginning, in my experience, being as well informed as you can be is one of the best defenses, because there are members of the public who either because they really believe something or because they want you to think that they know better than you do, will come at you with what you're supposed to be doing, and sometimes they're just wrong.
Yeah.
And so one of the best parts about being an empowered board is understand what you are required to do and what you're not, and then that helps to sort of make you not feel like you're in over your head, you know.
Yeah.
Well, thank you so much for your time, Eileen. This was very informative.
It was
Yes,
my
thank you
pleasure.
very much.
Thanks for having me. And anytime you want to do this again, we'll do it. Hopefully in person next time, but thank you all for staying. And I apologize for keeping you late. I hope that there was some stuff in it that made it worth it.
Super valuable. Thank you.
Thanks,
All
Skylar.
right. I
Bye.
call
Skylar
this,
for arranging.
yes, thank you, Skylar.
Yeah, no problem. Hey, Catherine, hang on one sec. There is one person who is in the audience, Kathy, who had her hand raised, and I'm not sure if you want to take her question, but I think since she's on the Sunset Empire Transit staff and has been on their board.
She's trying to get free legal advice. That's what she's trying to do.
Yeah.
No, I'm not.
Kathy. Oh, there you go.
You know, this is the Park and Recreation District's dime. So if you're okay with it, I'm okay with it, but you make that call.
I think it's
not a
fine.
question. It's not so much a question for Eileen as just to say, hey, I'm a fellow special districts member. I'm also a board representative. I'm on the special districts board, and there are lots of resources, and I'm happy. I live here in Seaside. I'm a phone call away. If anybody has any questions, I'm happy to help. There was one thing, Eileen, I just want to make sure that because I don't feel like you really said a whole lot about it, was the envelope of protection that the executive session provides is burst if you talk about things that aren't part of the reason you're in executive session. I know you brought it up. I just want to really stress that. I know it was a big issue for us with Sunset Empire Transportation District a couple times. And so it's just really important to remember, as soon as you start talking about the birthday party that you want to plan, then you blew your executive session. But in general, make sure you sign up for the conference for SDAO, and I'm here in town, so, you know,
Thank you,
practice
Kathy.
makes perfect. Lots of years of practice with SDAO.
Any last comments before we call this meeting adjourned? All right, meeting adjourned. Thank you, everybody.
Thanks, Kathy.
Thanks, Eileen.
You're welcome. Thank you guys for doing all the hard work.